everybody, this is Arkady Frekhtan, a New York City personal injury trial attorney, and today we're talking about bimalleolar and trimalleolar fractures. Very serious fractures, often requiring surgery, known as open reduction internal fixation. And we're going to look at recent verdicts in New York, as well as settlements. And let's start with the first case. Briefly, before we get to the case, maybe let's talk about what a bimalleolar fracture is. What it is when you have a bimalleolar fracture, bi meaning two, you have two broken bones in the ankle. And one is the lateral malleolus, which is on the side of the ankle, and the other is the medial malleolus, which is in the middle of the ankle. And if you have a trimalleolar fracture, then you have both of those fractures that I just described, but you also have a fracture of the posterior malleolus, which is in the back of the ankle, closer to where the heel is. So that's a serious fracture. And let's look at some recent results. So here's a result, and this is sorted by most recent. So it's going to be a range of all types of cases, all types of verdicts. One of the most recent ones that I was able to find was from April of 2022, this year, and it was out in Suffolk County, and there was a settlement of $100,000. What happened there was a child who was 12 years old was a pedestrian crossing a road, and he was hit by a car. And the car he was an underinsured motorist, which means that he didn't have enough insurance. So what happened was the boy suffered an open grade humeral shaft fracture, a right bimalleolar ankle fracture, and a right tibial fracture. He had a left ankle fracture, and he had a right ulnar styloid fracture, and he required surgery. So that's a very serious injury, and what happened was the insurance company, in this case Allstate, paid $99,000, and then the respondent's insurer paid $1,000. So that was a settlement during trial. And the next one is also in Suffolk County, and what happened here was somebody was on a property, and they claimed that they were there because they were doing a survey, and they produced their cell phone records to prove that they were in fact there, and they fell and suffered a bimalleolar left ankle fracture, which required ORIF, that's the open reduction internal fixation surgery, and it resulted in surgical scarring, permanent limited motion with numbness, and it was just a snowy driveway in the property. And what happened in this case was they found that the defendant was liable, and they found for the plaintiff, but they assigned the plaintiff 68% of the negligence. So most of the negligence went to the plaintiff. I guess he was maybe walking unsafely or doing something that was not in accordance with reasonable care, right? Because he got 68% of fault. And the plaintiff, and the recovery that the jury allowed for was $51,600. So that's relatively low. But maybe because the plaintiff was at fault. Okay, let's go to the next case. The next case here is in Genesee County, which is way upstate New York. And what happened there was a 14-year-old female pedestrian, and she suffered a right trimalleolar ankle fracture and had subsequent surgical scarring together with contusions, abrasions, lacerations. She was struck by an uninsured motorist, and then the plaintiff argued that the insurance company should be responsible for covering her medical expenses and other damages, and the damages were disputed, and the minor plaintiff finally received written consent from the defendant to settle her uninsured motorist claim. And the settlement here was relatively low. It was $20,000. Okay, let's go to the next one. The next one is a case against the County of Nassau, which is also in Long Island. And here there was a pedestrian, and the pedestrian was standing and waiting to cross a roadway on the flat yellow painted divider separating west and east. And she was struck by a police vehicle, and the police was in the course of his employment for the County of Nassau, and that's why the plaintiff sued the County of Nassau. And the plaintiff here was a 58-year-old female who suffered a trimalleolar fracture of the left ankle requiring surgery and the possible future ankle replacement She had multiple metatarsal fractures, arthritis, and emotional distress, which required her to have lifetime psychological counseling. And the jury found the defendant and the county 100% liable, and it allowed for $4.4 million in damages, total damages. It was actually, the compensatory pain and suffering was $3,250,000. The past medical was $105,000. The future medical was $700,000. The past wages were $166,000, and the future wages were $215,000. So the total was $4,436,259. So that's more in line with, what I would, expect to see. I mean, that's a high number, but, a settlement, from my experience, a settlement, something like that, a trimalleolar, bimalleolar, anywhere from $200,000, $300,000, $400,000, $500,000. A verdict could be into the millions. This is a good one, 4.4, but the other ones didn't really seem to make sense unless it was really limited policies, because 20,000, 50,000, that's very, very low numbers for something like that. This is a very serious injury. Okay, the next one is also Nassau County, and this one involved an adult who suffered a trimalleolar fracture to her right ankle, which required open reduction and internal fixation surgery, and she had a permanent impairment when she slipped and fell on ice in the student parking lot of Malloy College, which is a private college, and it was several days after a snowstorm. So if the snowstorm is over, then they should have cleaned the snow. And the plaintiff argued that Malloy failed in its duty to keep and maintain its premises, including the parking lot, in a reasonably safe condition, free from hazards. And the plaintiff argued that the defendant allowed a dangerous, unsafe, and deceptive accumulation of snow and ice to remain for an unreasonable period of time, failed to salt or sand the lot, resulting in the plaintiff's fall and permanent injury. And a jury returned a verdict in favor of the plaintiff. And the total verdict here was $1,136,211. So that's more in line with what I'm used to seeing. So that's a serious injury, and it was a relatively serious amount that the plaintiff won, especially in Nassau County, because Nassau County tends to be a little bit more conservative. Here's one in Kings County, which is Brooklyn. And what happened here was that a 16-year-old male suffered a left bimalleolar ankle fracture while crossing the street as a pedestrian struck by a car. And he made a full recovery, and his father brought a claim as an infant against the defendant, and the defendant denied any fault. And here it says that there was a settlement, and the settlement was only $35,000. Now, it doesn't say why it was so low. Perhaps the car only had $50,000 in insurance, and they settled for 35 out of the 50, not to risk, because it was an issue with liability, with him being a minor and crossing the roadway. But that's just a guess. Like, it doesn't say, so I can't really tell you exactly what happened there. And here is one in Saratoga County, which is Saratoga Springs. That's where they have the horse racing. That's way upstate near Albany. And here what happened was it involved a school. There was an 11-year-old boy. He suffered a bimalleolar ankle fracture requiring open reduction internal fixation while attending an intramural gymnastics class at an elementary school. And what happened was he fell from a rope swing onto the mat, and the minor parents alleged the defendants and their employees negligently supervised the students in the class and allowed the area underneath the rope swing not to have adequate and protective padding and surfacing. And the defendant denied liability, and the case settled. It settled for $20,000. Again, a low amount. I guess those kind of cases are tough though, because when you get injured in a gym class, I had a case like that too, where two people were running towards a soccer ball, and the soccer ball was in the middle, and then one was a little kid, my client, and one was a big kid. And so as they run towards the ball, what happened was they got there at the same time. They both tried to kick the ball, but the big kid kicked the little kid's leg and broke his leg. And we went all the way up to the appellate division, but ultimately they said, look, that's something that's unavoidable, because, it's just something that happens. They had no notice that this was going to happen. This could not have been prevented. My argument was that, they knew that this could happen, right? It's a dangerous game. Why play this game where you're both running and they're completely different kids? One is in, let's say, 4th grade, the other one's in 6th grade, one is like much bigger, the other one's smaller. Why play this game? Isn't there anything else that you can play in your curriculum that won't involve shattering children's legs? But the appellate division didn't like it, and they threw the case out. So, these cases are tough. Okay, here's a case, DeSena versus Good Samaritan. This is a case from Suffolk County, and this is a case where it was a patient at Good Samaritan Hospital suffered a bimalleolar fracture of his right ankle and swelling in his lower leg and foot after a defendant employee offered to wheel him to the exit doors in a wheelchair, and he was caused to be propelled from the wheelchair when the wheels hit an elevation that existed at the threshold of the exit doors. The plaintiff argued that defendant was negligent for causing and allowing an obstruction to exist at the doorway and for failing to provide and utilize a wheelchair and accompanying safety belt that would be sized for his height and weight. The defendant contended that the plaintiff was contributorily negligent for leaning forward, trying to stand up as the wheelchair approached the exit. The defendant also contended it possessed neither actual nor constructive notice that any sort of defect existed. So this is an interesting, kind of a different case. And the verdict from the jury was actually a defense verdict. So they said that the defendant was not at fault. And the plaintiff had an expert. They had an engineering expert, a safety expert, I guess, to talk about this elevation. It shouldn't have been there at the threshold of the exit. Maybe the plaintiff was so happy that he was leaving the hospital that he stood up a little bit, or the jury didn't believe that the defendant did anything wrong. But in my mind, look, if they had the seatbelt, if the seatbelt was on and the seatbelt should have secured him, then that would have prevented it, because even if he was lifted, the seatbelt should have prevented him from falling out of the wheelchair. But that's a serious injury to have a bimalleolar fracture like that. Okay, let's go to the next one. The next one is upstate in Onondaga County. Honestly, I don't even know where that is. That's way upstate. And it is a case where an adult female suffered a displaced bimalleolar left ankle fracture and was required to undergo the open reduction internal fixation. She was at an evening lights exhibit at a park owned and operated by the county, and she was walking on a trail and she tripped and fell off the edge of the trail due to a height differential between the trail and the adjoining land, because there was a deteriorated condition at the trail's edge. And the plaintiff contended that the defendant was negligent in failing to maintain the trail in a safe manner, failing to inspect, failing to provide a safe walking area, failing to warn. The defendant denied everything and argued that in preparation for the exhibit, its staff drove through the park to check for any dangerous conditions, and no concerns with height differentials were noted. And the result was that the jury found that the defendant was not negligent. It was a defense verdict. That means the plaintiff got nothing. So again, see, these upstate cases are very tough. That's near Syracuse. Okay, Onondaga County is near Syracuse. That's tough. They're tough cases. Here's one in Brooklyn. The one in Brooklyn involved a 65-year-old man. He suffered a bimalleolar fracture and a comminuted fracture of a distal femoral diametaphysis. Now, comminuted means it's broken into pieces. That's a very serious fracture. And he had intra-articular involvement when he was walking on a sidewalk adjacent to property owned by the defendants, and he slipped due to snow and/or ice. He argued that the defendants were negligent in failing to maintain the property in a reasonably safe condition and engaging in snow and ice removal efforts, which created a dangerous condition on the sidewalk. So when you remove snow, you have to do it in a way that you don't leave ice on the sidewalk, because then you could create the condition. You could exacerbate it. Means making it worse. And the defendants denied liability. They denied the plaintiff fell on the sidewalk and contended the plaintiff fell on a pedestrian ramp for which they were not responsible. Okay, so I guess the issue here was where the fall happened. They were arguing the fall happened somewhere else completely. And so the jury returned a defense verdict again, 0. And actually this plaintiff I see here from the lawyers, he had a really good law firm. He had excellent lawyers. So I guess there was some evidence that he might have fallen on that ramp for which the defendants did not have any responsibility. Okay, now we're going to go to another case in Suffolk County. And this one was a settlement of $20,000. It involved a fracture of the ankle, bimalleolar ankle fracture requiring open reduction internal fixation. A bicycle that the plaintiff was riding was struck by a car, and it was only a $20,000 settlement. That's really low. Here's one from Onondaga again, another defense verdict. Let me go through these to see what's going on here. Here we got one in Kings County, that's Brooklyn. What happened here was the plaintiff was nonverbal, 46-year-old female, and suffered a trimalleolar fracture of her left ankle when she slipped while exiting a parked Ambulette. And when she went down the steps, it was raining, and she argued that they were negligent in failing to assist her to get out of the Ambulette. And the damages were disputed. And what happened was the jury found for, it was a retrial. For whatever reason, the first trial, the jury found for the defendant and his employer, but there were some issues that required a new trial, I guess appellate issues, some errors. And so in this case, they found for the plaintiff, and the verdict was $920,000, almost $1 million, and it was a compensatory pain and suffering verdict. So that's pretty good. That's a good result. And I know the lawyer who tried this case too. I know that they're a good firm. They're in Manhattan. I've worked with them before. They're very good. Okay, so here's another one in Brooklyn, Kings County, and this one. An adult female. She suffered a bimalleolar fracture of her left ankle, which required open reduction internal fixation surgery. She was exiting her apartment building owned by the defendant and managed by another defendant management company via an exterior pedestrian ramp, and she slipped and fell due to an icy condition on the ramp. The plaintiff contended that she fell due to a dangerous and defective condition, and the defendants failed to remedy or correct the condition. The defendants denied liability and argued that they had entered into a contract with a third-party security company and said that they were supposed to take care of the ramp. And it was a breach of contract. And they also reportedly claimed the plaintiff was negligent. A jury determined that the owner was 50% at fault, the management was 50% at fault, and that the plaintiff and this third-party security company were not at fault. And then the verdict was a total, let me see here, a total of $4,125,000. It was $4 million for compensatory pain and suffering. I guess that includes both past and future. And then future medical expenses were $125,000. So that's a very good verdict. That was in Brooklyn. This was in, let me see. Oh, this was a while back. This was in 2017. But yeah, this is a good verdict. And also I know the firm that handled it for the plaintiff, a good firm. So this is a good result. The next one is in the Bronx. And what happened here was an adult female suffered a trimalleolar fracture of her left ankle, which required surgery. She also had chronic neuropathic pain and swelling and complex regional pain syndrome, known as CRPS. That's very, very serious. And she was going down a stairwell at a property owned by the defendant and managed by another defendant. I think a realty company owned it, and then some property services company managed it. And she tripped and fell due to a cracked or broken stair. And she argued that there was a dangerous and defective condition, and the defendants had actual and constructive notice of this condition and were negligent in failing to maintain the premises in a reasonably safe condition. And the defendants denied liability and argued that the plaintiff was negligent, and a jury determined each defendant was 50% at fault. So the manager was 50% at fault, and the landlord was 50% at fault. And the total verdict here was really, really high. It was a good verdict for the plaintiff. The total verdict was $12,677,744. They used an economist for future wages. Actually, we use that expert as well sometimes. It's a very good expert. I know the law firm. It's a good law firm. that does a lot of personal injury as well as workers' comp, I believe. And so the compensatory pain and suffering was $9 million. The compensatory past medical was $179,000. The future medical was $2.5 million. The past wages were $71,000, and the future compensatory wages were $880,000. So the total was $12.6 million. So that's an excellent result in the Bronx. Let's do one more. Okay, here's one in Nassau, and this is Long Island. Oh, this was actually a defense verdict. I don't know if this is so exciting. Let's see what happened here. It was a female high school student who suffered a bimalleolar fracture of the tibia and fibula of her left ankle when she slipped and fell on droplets of liquid through an audience participation cultural event in her school's cafeteria. So that's tough, yeah. When you have like a little bit of droplets, I mean, that's hard for them to. They'll probably argue we didn't know about it. It might have been caused right before, a second before. We didn't have any notice. I'm just going to go through a few of these. I see some other defense verdicts here. Here's a defense verdict in Suffolk for a bimalleolar fracture, trip and fall on snow and ice in the parking lot. Those are tough too. Here's one in New York County, which is Manhattan. And this one involved a bimalleolar ankle fracture. And it was a passenger in a car rear-ended by a vehicle by the defendant. The plaintiff argued the defendants were negligent in the operation, management, use, and control of their vehicle, and that the other defendant followed too closely. So the plaintiffs actually won on liability because it was a rear end. So they won on liability. So the case went to trial only on damages, but unfortunately the jury found that the plaintiffs' claimed injuries were degenerative in nature, which is odd because a degenerative bimalleolar ankle fracture? Because an ankle fracture like that, usually is traumatic. It's a pretty serious ankle fracture. I see the plaintiff had other injuries, meniscus, arthroscopic surgery, shoulder impingement, tears in their labral tears, required surgery. I mean, I could see how those could be degenerative, meaning, from living your life as opposed to a traumatic event, but bimalleolar fracture, I don't think anyone's walking around with a bimalleolar fracture. I don't really get that part of it, but you never know what a jury's gonna do. And here's a case in Nassau County. This was also a defense verdict. A lot of defense verdicts out in Long Island. Here's a premises one in Queens. It settled for $25,000. That's really low. This was a bimalleolar fracture of a 7-year-old. And he was lowering his chair from a desk and began to slip and fall, which caused the chair to fall and strike his ankle. And then there's one here in Brooklyn. Okay, let's end with this one. This looks like a good one. Oh, actually, I know this lawyer as well. I've had some cases with him. Actually, I know him personally. He's a good lawyer. Here's what happened. And a man suffered a left hip fracture, a left bimalleolar ankle fracture, multiple metatarsal foot fractures, and multiple toe fractures of the left foot, as well as a concussion with loss of consciousness when he was struck by the side of a public commuter bus owned by the defendant, New York City Transit Authority, and operated by the defendant, driver, during the course and scope of his employment with NYCTA. The plaintiff argued that the driver operated the bus with the permission, consent, and knowledge of the New York City Transit Authority. He was reckless and careless, speed under the circumstances, failed to keep a proper lookout, failed to yield the right of way to the pedestrian, failed to prevent his vehicle from striking the pedestrian, and maintained that it failed to properly train, supervise, retain this driver. And the defendant denied liability and claimed that the driver failed to keep, that the plaintiff failed to keep a proper lookout and was talking on his cell phone and was on cocaine and was intoxicated at the time of the crash. So the jury returned a verdict in favor of the plaintiff, and the total compensatory award or amount that they allowed for was $2,200,000. So that's a pretty good result in Brooklyn. And the case went to trial. It was a jury verdict. Okay, I hope this has been helpful. These are just some of the recent verdicts for bimalleolar and trimalleolar fractures. We'll do some other ones about other topics. Let us know what injuries or what type of incidents you would like to see. Okay, everyone, thank you for watching. Like and subscribe to our channel, and we are here for you. Have a great day.